Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a recent Ontario court decision about math, schools, and race. The case was a challenge to Ontario's new Math Proficiency Test, a new standardized test that teacher candidates are required to take in order to become a fully qualified teacher. The test includes math questions from grades 3, 6, and 9. The test was developed in order to help improve math test scores among students by improving the math skills of teachers, as student scores had been dropping. But a group of teacher candidates, supported by the Ontario Teachers Federation, challenged the exam on the basis that the test was an unconstitutional form of discrimination. The test results were showing a considerable disparity between test takers along racial and linguistic lines, with some language speakers and some ethnicities failing at higher rates. The divisional court ruled on this case recently and found that the test did amount to unconstitutional discrimination. Here today to discuss the case are two legal experts, Asher Honigman and Omar Haradai. Thank you both so much for joining me today. Mr. Honigman, let me start with you. What can you add to the background? What can you tell me about the test itself and why the government took the position that this test was not discriminatory?
Well, the test itself was brought in, as you said, because we've had falling math scores in Ontario and across much of Canada for some time. Math is taught very differently today from the way it was when we were kids. There's not you don't really get that rote memorization anymore. They brought in what's called new math, and they've been trying to improve math scores. And this test was one way of doing that. And as you said, the divisional court took the position that not only the test actually, but the entire regulatory framework that allowed for the test development was unconstitutional. We'll get into that, but that's a very strange finding in and of itself. The court didn't just say this test is unconstitutional, but the entire regulatory framework has to go.
So, Mr. Haradai, what can you tell me about what the teacher candidates supported by the Teachers Federation were arguing here? Can you elaborate on their concerns over the test and why it amounted to discrimination?
Certainly, and I think, Christine, you've touched on it, that this is part of a broader conflict between teachers in Ontario and the province of Ontario. So there's ongoing conflict over money, class sizes, COVID safety, a whole myriad of issues. And so when it comes to this particular issue, the problem was that the test was hurried, it wasn't properly structured or reviewed or vetted, and the government's own math experts encouraged them not to proceed with it based on some of the pedagogical problems or challenges inherent in the test. And so that is really where we're having an issue, is where government is getting directly involved in how teaching should be done when the teaching experts are saying it should be done differently.
Mr. Honigman, your view on what the court found, they found that this was discrimination because some racial groups, some ethnicities performed poorer on the test. What's your view on that interpretation of our right to equality under the Charter?
Well, I mean, there's two issues there, Christine. One is, if I'm looking at the Charter as a matter of first principles, how do I believe it should be interpreted versus what has the Supreme Court said? Now, the Supreme Court recently said in a case called Fraser that we do have to look at these disparities, that you don't just look at the law, you have to really go behind the law, and that you don't even necessarily need the same kind of causal connection that we would typically ask for between the disparity and the law. Now, there have been other cases. There's a case in the Federal Court of Appeal called Weatherly that interpreted the Supreme Court's case much more narrowly than this case did. This case, I would argue, took the Supreme Court's case and broadened it such that we don't really need evidence at all that the disparity is caused by the law, that the disparity ipso facto is enough to say that there is discrimination. My view is that while we should be prepared to look behind the law somewhat, we can't start getting into these policy realms. We have to say, is this law essentially on its face discriminatory or is it not? Now, there will be some laws that look facially neutral, and you can look behind it. If you say, for example, that a pregnant person can't get this benefit. Well, obviously that's discriminating against women. And that's the very reason Section 15 was enacted, to get behind laws that look facially neutral. But that doesn't mean that every time we have a law that we go well beyond it. We look at all these facts and we say, is it discriminatory? Is it not?
We've got to go to commercial, but we will be right back. Welcome back to Canadian Justice, where we're discussing a recent Ontario case about math, race, and discrimination. Mr. Haradai, I want to follow up with you on the question from the last segment, where the Divisional Court had found that this test, which some racial groups were performing failing at a higher rate, they found that this was discrimination. What's your take on whether or not that rises to the level of discrimination in violation of Section 15 of the Charter?
Yeah, so my biggest concern here, Christine, is that I don't want people to interpret either the court's decision or the circumstances around the court's decision as that certain populations, ethnicities, or races are worse at math than others. I think that would be the wrong conclusion. This test wasn't just about math. I think that's important to keep in mind. It was also about, as Asher described, the pedagogy of math. How do we teach math? And so if you have a whole number of people who have learned math differently, perhaps learned math in different countries, it was that specific component of the exam that they were having difficulty with. In fact, there was affidavit information before the court of an individual who knew math very well and passed all the math components, but couldn't pass the part that was about how to learn math or how to teach math.
Interesting. All right, that's an important part of the evidence of the case, that this test had more than just these grade 3, 6, and 9 questions. Correct? There was also a teaching component of it.
Exactly.
Okay.
So, and that has evolved over the years, but also, as you can imagine, people learn math differently. If you're from China or India or parts of Africa, it doesn't mean that they don't know math. It's just that there are different learning approaches towards math around the world.
I think that's an important point. One of the things I want to turn to now is about whether or not, in this case, though, the court appears to have substituted a policy preference for the government's policy preference. The court based part of its reasoning on the fact that the standardized test isn't the best way to achieve higher student scores. That it may not achieve that goal very well at all. But to what degree is that getting into the court substituting its own preferences? Asher, what's your take on that?
Yeah, this is the problem when we interpret discrimination and equality so far beyond what the law actually says, that invariably courts will get into the shoes of the legislature and start making these very complex policy decisions. Like there's no doubt that this is a difficult issue. Nobody's doubting that. Nobody's doubting, I think, in good faith, that this is a problem we need to address. If people from certain groups aren't performing as well on tests as others, that is a problem. But the question of how to address that problem needs to be left up, in some sense, to experts, but also fundamentally to our elected representatives, whom we elect specifically to address those types of problems. And what the court does in this case is it says, well, this test is no good, but a course would be much better. And a course wouldn't be discriminatory. And the response to that is, how do you know? Why? The very same reason that this test is discriminatory, it could turn out that the course is discriminatory. Maybe the course is taught, disproportionately by white people, and therefore white students of that course are likely to do better than non-white students. We have no idea that, and for the court to say, we know this is not good, but we know that this would be better, they are making an inherently legislative choice.
I think that's a really important point. That was part of what the court talked about whether a course itself would be better. But Mr. Haradai, if there was still a disparity in students along racial lines of the failure rates of a course, would the course then be discriminatory as well?
Well, I have a slightly different take than Asher does on this topic, because the Supreme Court of Canada did confirm in a case just last year, Nelson and Marchi, about the type of governmental decisions and policy decisions that are insulated from judicial scrutiny. So there are certain factors, certain aspects that the courts are not going to want to touch. In this particular case, the reason why the courts are getting involved is because the government decided to directly get involved in education. In other words, the arm's length regulator, which didn't want to proceed in this way, was forced to proceed this way because the government enacted legislation. And so because the government is getting involved, they are, by nature of their involvement, attracting more scrutiny about the way that they get involved. And so if the regulator made that decision themselves, I think it would be a different situation. And to more directly answer your question,
Omar, we've got to go to commercial break, but how about you answer that, the question about a course versus a test when we come back from commercial break? Welcome back to Canadian Justice, where we're discussing a recent Ontario case about math, race, and discrimination. Now, Omar, in the last segment, I'd asked you about if a course was used to be required for teacher candidates instead of this exam, and it turned out that there was a differential impact of that course along racial lines, if that course itself would also be discriminatory.
Yeah, the difference there, Christine, is that the course is not being offered by the government. So there's an arm's length college or university that's offering the course. And if there are disparate impacts, it's more removed from the government's direct involvement. And so I think that's the distinction here that the court's making.
So I want to switch gears here to something else. Part of what this comes down to is perhaps a different understanding about equality and this difference between substantive versus formal equality, or perhaps another way of phrasing it is maybe equality of opportunity and equality of outcome. And I wanted to know if Asher, we'll start with you, if you could expand on what the difference between those two notions of equality are and how that kind of tension applies in this particular case.
Yeah, absolutely. Well, first of all, I would say it's somewhat of a false dichotomy. Traditionally, we think of formal equality as just looking at the law on its face, a law that says, Gentiles can go to school, but Jews can't go to school, breaches formal equality. But a law that says everyone can go to school doesn't breach formal equality. Whereas substantive equality, we say, let's look behind the law, let's look at how this impacts certain groups. Now, the problem is within what we call substantive equality, and there's no doubt that Section 15 protects some conception of substantive equality. It's the only section in the Charter that took 3 years to come into force after the Charter was enacted. Clearly, it was meant to do something new. The question is, what does substantive equality mean? And you can take a very extreme view like they do in this case and like Fraser does, which is that we have to do a deep dive into how this law affects this group and that group, or you can take substantive equality in a much more limited way and treat it as really just substantive legal equality. In other words, we still say, how is the treatment of this group versus the treatment of that group? Not how does this group perform and that group perform, but what is the legal treatment? Because that's what the text of Section 15 says. It talks about equal benefit of the law. And so a law that says something like, we were talking before about pregnancy, but a law that says something like, you can vote on Saturday, everyone will vote on Saturdays. Well, Jewish people could come forward and say it is a fundamental aspect of Judaism that Saturday is our Sabbath. That is well known. That has always been a feature of Judaism. It will never stop being a feature of Judaism. So even though this law looks neutral, it's not. That's much different from saying people in this profession should earn more than people in this government profession, and then coming forward and saying, well, actually, look, people in this profession tend to be male, or they tend to be Black, or they tend to be Indigenous, etc. Those are things that can change at any point in time. Those statistics can change. And so I'm in favor of looking beyond the law, certainly looking at the facts, but not doing this deep dive, because once you get into that, not only are you going really beyond what the Constitution says, in my view, but as I said, you're getting into what I believe is a fundamentally legislative question. You're getting into how do we decide these complex issues?
Omar, I want to give you a chance to respond, as I'm sure you have an opinion on this tension as well.
The best way to create, let's say, more opportunities is by also looking at outcome, not perhaps an exclusion, but you have to look at it. And I disagree with Asher to a certain extent that what he is describing as a deep dive, those things were happening from the very beginning of Section 15 jurisprudence. We can look at some of those cases like a firefighter who's a woman being held to a male standard for physical fitness as an example of looking at outcomes.
Which is a very famous Section 15 case, those exact facts.
Exactly. And so the distinction isn't that different here. I think what makes this unusual, again, is the context of the government's involvement, the very high tensions between the government and teachers, and some of these other consequences that weren't even properly considered when making this test.
Well, Asher, I want to give you a chance to respond to that as well. What direction do you think the courts are going with equality? Is it moving towards sort of Omar's view or your view, in your opinion?
Well, it seems to be moving more towards Omar's view. But I think what you'll see is that when these decisions come out, lower courts have an increasingly difficult time dealing with them. And that could cause the pendulum to swing.
We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing the issue of a case involving math, race, and discrimination. Now, Asher, I want to start with you about this question of how could this reasoning from this case be applied outside of the teaching context? There are many professions with licensing requirements. Lawyers, for example, take a bar exam. And if there's evidence of a disparate outcome along racial lines in other professional licensing requirements, would that mean that those exams are also unconstitutional?
That's a great question, Christine. I would say that the logic of this decision can be applied to really any other profession, any other regulatory context. You mentioned lawyers. Lawyers are regulated by the Law Society. And here's where I push back against what Omar was saying earlier, that the Law Society is in one sense an arm's length regulator, but the law is very clear that it is subject to the charter as well. It is in effect an arm of the state. I don't think we can separate the government from a regulator, even when that regulator enjoys independence. It's still an arm of the state. It's still subject to charter scrutiny. And if we find, for example, that one group is getting licensed more than another group is, that one group is doing better on the bar exam than another is, I don't see how, based on the logic of this decision, that would not be subject to judicial scrutiny. And we'd have judges, again, looking at this profession and that profession and saying, this is equal, this is discriminatory, etc.
Omar, same question to you. Do you think that this logic from this case could be extended to other sort of professional examinations?
I think it could, and I'm hoping that it isn't, let's say, indiscriminately, because I would have some concerns about it happening in that way. I just don't know if it would apply in the same way. It would take the government of Ontario to say, let's say lawyers must all study when they're studying the law and highlight with yellow highlighters. And then, for example, a certain group under Section 15 doesn't use yellow highlighters and is then failing the bar exam. Like, there would have to be significant government involvement. I agree with Asher that there is scrutiny when it comes to regulators that are arm's length, but there's also a very important goal that the court was looking at, which is the diversity of the teachers in the profession. And they said racialized students benefit from being taught by racialized teachers. I'll take it further. I'll say everybody in Ontario benefits by being taught by a diverse number of teachers because we have different perspectives, different views. And I think that's really the crux of this case, is that the government, when creating the test and implementing this, didn't consider all of those unintended consequences and what the other bigger picture objectives of this process of licensing teachers was intended to achieve.
Yeah, I'll close on that last question, that there are potentially competing goals here of ensuring, or I don't think they should be competing goals, but they apparently were for this court, of ensuring a diverse teaching profession and ensuring that there are teachers that are all proficient in math. And Omar, in your view, the court was finding that the government got the balance wrong in those two goals, which I, again, say I actually don't think need to be competing goals.
They don't need to be competing goals. I think they ended up becoming competing goals here because the government was trying to transform our education system as it related to math, but they were doing it in far too hurried a manner and not relying enough on their own experts as it comes to math education. And so I think that's really where they fell short.
Asher, 30 seconds, last remarks you want to make.
I would just say these goals are not in conflict at all. The fundamental question is who decides how to balance these goals and how to achieve them. And I just fundamentally push back on the notion that the government, the people that we elect, should not be making education policy and should have to defer completely to arm's length regulators. I reject that.
Well, I want to thank you both so much for coming on the show today. I really want students to have both a diverse teaching professional, and I want them also to achieve high scores in math. I think we can all share those values today. Thank you both so much for coming on to share your time and expertise.
Thank you for having us.
We've heard today about a case where a math test was declared unconstitutional during a time when courts have upheld quite extreme restrictions on Canadians' movement, assembly, and even speech. The court stepping in to stop math seems a little strange. Is this a step towards substantive equality, or is this an example of the court substituting its own policy preference? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.